I mean, literally national publicity, just banging out not guilties after not guilties. And I'm watching these lawyers, I'm like, I'm just trying to work on my art and get people and fight these cases. And I think the way you build it is you get that big case, but you show the world who you are.
In a recent legal twist, Lil Durk's defense team released new court filings that sent federal prosecutors scrambling, almost as if a spotlight had been thrown on them without warning. Attorney Drew Findling, widely recognized as one of the most high-profile criminal defense lawyers in the country, submitted a motion that, in effect, challenged the government to either present its evidence or step back entirely. And the moment it hit the docket, the momentum in this case shifted sharply toward Durk. No dramatization, no embellishment, just the reality of what unfolded. Before we unpack the significance of this move, stay locked in, because what follows explains why some analysts believe Lil Durk's legal outlook may be changing more rapidly than expected. To understand how we arrived here, we need to revisit the moment this case first began to unravel. Federal authorities have long asserted that Durk orchestrated a murder-for-hire scheme targeting Quando Rondo. According to their narrative, he authorized a payout and relayed instructions to associates. But here's where the cracks in the story begin to show. Those allegations have remained remarkably undefined. Prosecutors have repeatedly suggested Durk ordered it. Yet when Findling pressed for specifics, when this supposed order was given, where it occurred, how much the alleged bounty involved, or what words were used, the record fell silent. The government continued to describe the broader violence, the pursuit, the confrontation, the surrounding events. But when it came to establishing that Durk himself directed anything, concrete details were absent. And that is precisely what Findling underscored in the latest filing. This is strategic, high-level legal maneuvering, so let's break it down. His team submitted what's known as a motion to dismiss on the grounds of vagueness, a term that might sound dry, but in federal court, it carries serious weight. The argument is simple. Charges that lack specificity deny a defendant the ability to mount a fair defense. Think of it this way. Imagine being accused of a robbery, but investigators can't identify the store, the day, the time, the amount taken, nothing. How can you account for your whereabouts if the accuser can't define the where to begin with? That mirrors the situation at hand. Prosecutors reference an alleged bounty, yet still can't state when the offer occurred, where any discussion took place, what language was used, how much money was involved, or who supposedly witnessed it. And this ambiguity has persisted for nearly 2 years. But that's only the surface layer. The true turning point emerged when Findling highlighted inconsistencies from the government's key witness, identified in filings as PW1. According to the documents, this witness has revised his narrative repeatedly. At first, he denied any bounty existed. Later, he claimed he never accepted money to harm anyone. Then he suggested he acted under pressure. Now, the latest version alleges that a member of Durk's circle remained in Los Angeles to receive and distribute bounty funds. But here's the pivotal detail. The prosecution's own material contradicted that claim. It was removed entirely from the second indictment after the witness's account failed to align with documented evidence. Findling summarized the issue sharply. When the government's primary witness alters his story on essential points, the defense is forced to respond to a constantly shifting narrative, a scenario fundamentally incompatible with fair legal process. This is where deeper analysis began to surface. Prosecutors had attempted to lean on Durk's music, pointing to lyrics as supporting evidence. But in this motion, Findling dismantled that approach, stating in clear terms that if the government cannot substantiate its case without relying on artistic expression, then the challenge before them extends far beyond this single motion. And that argument lands hard. Despite possessing vast phone, it's a fragile argument at best, and what truly stands out is the example Findling used to illustrate just how unbalanced this process has become. He proposed a scenario. Imagine the defense is never told what coded language Durk supposedly used, only to have a witness appear at trial and claim, for the very first time, that a phrase like "the eagle has landed" was actually a signal to authorize a murder-for-hire payment. Under those circumstances, the defense would have no way to investigate the claim, no opportunity to locate rebuttal witnesses, and no chance to prepare a counter-argument. That isn't a fair trial, it's an ambush. And according to legal analysts, that hypothetical captures why this motion has become a major topic of conversation within the legal community. Several experts have already called it one of the strongest procedural challenges they've seen in a federal prosecution of this kind. At its core, Findling's filing exposes the broader strategy prosecutors appear to be using, a reliance on emotionally charged descriptions of the shooting, the pursuit, the imagery, all intended to overshadow the fact that they have yet to establish that Durk ever issued an order. It's comparable to showing a courtroom extensive footage of a bank robbery and then asserting, without supporting evidence, that an unrelated individual orchestrated the entire scheme. The visuals may be intense, but without a demonstrable link to planning, the accusation collapses. Yet, in this case, prosecutors argued that the specific language Durk allegedly used wasn't essential to the charge itself. Findling countered forcefully. In a murder-for-hire allegation, the offer, and the language conveying that offer, is as central to the offense as a misrepresentation is to a charge of wire fraud. Now, Here's what this all means for the trajectory of Durk's case. This motion forces federal authorities to reveal exactly what they have. They can no longer proceed with undefined claims and continually shifting witness testimony. Finling's position is unmistakable. Provide the details or withdraw the accusation. If prosecutors cannot identify the time, location, or substance of the alleged bounty discussion, the structural integrity of the case may be at risk, and the filings suggest they have struggled to articulate those details for nearly 2 years. The repeated shifts in the star witnesses' account pose an even deeper problem. Jurors are historically wary of testimony that evolves, especially when the witness is facing severe penalties and may be motivated to reshape events in his own favor. And consider this. Prosecutors have already had to remove portions of their indictment after discovering that the evidence did not support certain claims. That alone signals an initial overreach. But the true strength of this motion lies in its multifaceted impact. First, it challenges the cornerstone of the government's theory. If the alleged bounty cannot be proven, the murder-for-hire charge collapses, and with it, much of the structure built around it. Second, it highlights the fragility of the prosecution's witness base. A key witness who provides 4 conflicting narratives significantly weakens any case that relies on him. Third, it underscores the issue of prosecutorial inconsistency. Shifting theories midstream contradict the principles that guide federal prosecution and undermine the reliability of the entire case file. The grand jury rendered its indictment based on one narrative, yet the current prosecution appears to hinge on a different one, a discrepancy Finling pointed out unequivocally. And from a street-level lens, the logic becomes even clearer. Federal investigations frequently hinge on flipping someone within the inner circle. That person provides the narrative, and the case is constructed around it. But when that individual repeatedly alters key details, when the physical evidence fails to match their claims, and when they cannot explain the basic framework of the incident, the case begins to unravel. That is precisely what is occurring here. Prosecutors believed they had a straightforward path, but a closer examination reveals substantial gaps. Another factor: Durk was not in Georgia when King Von was killed, nor was he in Los Angeles at the time of the subsequent shooting. Therefore, the only method of tying him to these events is through the alleged directives he issued. But if the government cannot prove what was said, when it was said, or how it was conveyed, then establishing his involvement becomes virtually impossible. What Finling executed with this motion is a calculated and advanced form of legal offense. This isn't merely a defense tactic, it's a direct challenge to the government to present precise, verifiable information about the alleged bounty and supposed instructions. In doing so, he is compelling prosecutors to either reveal evidence they may not possess or concede that their theory has been built on inference rather than fact. And here's the strategic brilliance: even if the case isn't dismissed outright, the court could require the government to supply a bill of particulars, a detailed, point-by-point outline of the allegations. If prosecutors can't supply that information, or if the details contradict what they previously told the grand jury, Durk's legal team will be positioned to dismantle the case during trial. But let's take a broader view of this moment and examine its implications for hip-hop culture. For years, federal authorities have attempted to use rap lyrics as prosecutorial evidence, from Bobby Shmurda to YNW Melly, and now Durk, repeatedly blurring the line between art and criminal accusation. Finling's filing directly challenges that practice. His argument to the court is straightforward: if the prosecution's theory collapses without the use of lyrics, then the case lacks substantive proof. That stance could influence future cases by limiting how artistic expression is used in criminal litigation. Another factor working in Durk's favor is the timeline, which simply doesn't align. Prosecutors are relying on a song released 7 months before the shooting to establish intent for the alleged bounty. But using an artistic work created months earlier to prove intent for a specific later event is a logical stretch, akin to claiming that an artist who writes about bank robbery in January must be responsible for a real robbery that occurs in August. The chronology doesn't support the conclusion. And then there is the witness issue, the weakest point in the government's case. The witness initially denied any bounty existed, then claimed coercion, then claimed someone else handled the payment. Yet the prosecution's own evidence disproves that final claim. That leaves them with a witness whose credibility is severely compromised and who is tasked with testifying about the most critical component of their narrative. That will be a difficult sell to any jury. What's even more revealing is what prosecutors lack entirely. There are no recordings of Durk issuing instructions. No text messages referencing a bounty. No financial transfers indicating payment. No witnesses who heard the alleged directives. No physical evidence tying him to planning. What remains is a collection of circumstantial indicators and the testimony of someone whose story has changed repeatedly. That falls short of the standard required for a federal murder-for-hire conviction. Finling's approach is effective because he isn't simply responding to the government's claims, he's systematically attacking their reliability. By highlighting the inconsistencies and gaps, he is shaping the narrative a jury will internalize. Even if damaging evidence surfaces, jurors may question its weight in light of the government's inability to articulate clear, consistent allegations. That alone introduces reasonable doubt. The broader takeaway is significant. This motion may have fundamentally altered the trajectory of the case. The prosecution appears to have relied heavily on assumptions and unstable witnesses, perhaps believing that compelling imagery and dramatic details would overshadow the absence of concrete proof. But Finling has now illuminated those deficiencies. He has forced the prosecution to either substantiate their claims or withdraw them, and based on the record, producing that substantiation may be difficult. This does not guarantee an acquittal. Federal prosecutors still possess substantial resources and may attempt to reinforce their case. But it does indicate that Durk's position has improved considerably. This motion underscores an essential principle. The burden of proof lies entirely with the government. If prosecutors cannot specify when, where, or how the alleged bounty offer occurred, the structural foundation of their case could disintegrate. Public sentiment has echoed the phrase "Free Durk" since his arrest, but after reviewing the arguments in this motion, that outcome feels more plausible than before. Let us know your thoughts. Does Durk have a viable path to beating these charges? And stay tuned for ongoing updates as this story evolves.